strike the $15,000 liquidated damages from the judgment for pretty much the same reasons. They're exclusive, mutually exclusive remedies, and again, the very purpose of liquidated damages is to substitute for damages that aren't readily calculable. And if these other damages were to be awarded erroneously, we submit, then the $15,000 in liquidated damages would not be permissible. Okay?
Okay, and that possibly makes more sense. To me, that makes more sense.
And then there, if you put together the original memo, the original motion, Mr. Sitman's response, and our reply, basically sets out, I think we agree as to these minor mathematical calculations. In the response, the plaintiff has laudably conceded that double rent is not available. And then with respect to the argument at the end of the response, which I alluded to earlier, regarding the acceleration of rent, once again, Section 83.595 falls under the residential part of Chapter 83. It's not applicable. I'm happy to walk the court, I'm happy to step the court through the analysis. But just to be very brief, if I may approach, I just have an outline of Chapter 83 as well as some of the pertinent statutory provisions. Here's Section 83.595. Here's Section 83.40. Here is Section 83.41. Here is Section 83.43. And Section 83.06. And with the court's indulgence, just a moment to give my friend on the other side copies of the same. You got it? So directing the court's attention to the outline of the statute, you can see that the Florida statutes are broken down into titles, chapters, parts, and sections. Within Title VI, is Civil Practice and Procedure, is Chapter 83, Landlord and Tenant. Part 1 of that chapter is non-residential tenancies. On the following page, Part 2 is residential tenancies. Section 83.595 falls under residential tenancies, and that's the provision in both the complaint and at the end of trial, the plaintiff asserted, provided the opportunity to accelerate rent. It doesn't work that way. Section 83.40, the short title of Part 2, it says this part shall be known as the Florida Residential Landlord and Tenant Act. Section 83.41, it says this part, meaning Part 2, applies to the rental of a dwelling unit. Section 83.43, definitions, subsection 2A, says that a dwelling unit is a structure, part of a structure that is rented for use as a home, residence, or sleeping place. And Section 83.595, as I indicated, falls under Part 2, residential. There's no competent substantial evidence in the record indicating that there's a dwelling unit on this property. To the contrary, the complaint itself, in one of the first paragraphs on the first page, alleges that this was a commercial lease, not a residential one. And as Your Honor can see from the first page of the lease, there's a lease of the parking lot. Now, I really don't think there's any dispute that this is a non-residential lease. Therefore, Section 83.595, which was cited repeatedly as grounds for tens of thousands of dollars of damages, actually hundreds of thousands, over $400,000 in damages, simply inapplicable.
Are those in the judgment?
Those are not, but whereas my friend included it in at the end of his response and said that the plaintiff should be allowed to flip the switch and make a new election and threatened that the accelerated rent would come into play. I wanted to underscore to the court that that would be an erroneous award of damages.
All right, I'll certainly be skeptical of that issue, but you're in agreement then, as an alternative, that if, I know that you think that plaintiff should not be permitted to make a new election, but it's clear to the court that the election that we were talking about at that time is not this one between the 15,000 and the 40-something thousand in rents that would otherwise be due. It was in addition, in that discussion on the day of trial, in addition to the 40-odd-something thousand dollars in other rents that were due, because nobody would elect 15,000 over 40-something. So if that is in fact the case, is what you're saying now, if I produce a new election today, a permitted new election, then the proper rent with some mathematical calculations that you all made would be all of the rent, all of the damages in the judgment, except for liquidated damages in lieu of future rents, paragraphs 27, 28, and 29, and the double rent provision of paragraphs 10, 11, 12, and 13.
I think that's generally correct, Your Honor. I want to take pains to underscore that we believe that the liquidated damages is the cap. These other points, we only reach in the alternative if the court disagrees with us. We think that going that far is error. We also believe that a new election would be error. But that said, it just what Your Honor just indicated would be accurate. And by my calculation, just to make sure we're on the same page, by my calculation, that I think would bring the total damages from the 110-something thousand down to, I think, approximately 62.
Okay.
If I'm not mistaken.
All right. Mr. Senator,
Thank you, Your Honor. First, on the final judgment, paragraph C, you gave the defendants 45 days to file the financial affidavit.
I object because of this.
1.977.
hold that thought, Mr. Cal. Let me get a statement, and you can object to that.
On December 14th, Your Honor entered this order. Mr. Cowell asked for additional time because they had not complied with the final judgment, giving them to December 28th to file the affidavits. As of today, they still have not filed the affidavits. They haven't delivered anything. We asked for an order to show cause why they have not complied with this court.
I object because this filing I haven't even had a chance to see, and was not submitted 7 business days in advance for Your Honor's order. I don't think it should be heard today. It's a bit off topic.
Well, Mr. Cabell, it's not really being heard today. It's a request for this matter to be set.
And it was noticed, Your Honor,
I understand. The request for an order to show cause is not the same thing as having the hearing on the order to show cause, and that's fine. We can discuss this since we're all here. How about a response to Mr. Cabell's motion?
Thank you, Your Honor. Your Honor is correct. At the trial, and the transcript shows, the discussion was whether the accelerated rent is permissible and would be Chapter 83.595 because the lease states we're entitled to all the remedies under 83.595. We'd like to sit back, do nothing, wait for rent as it comes in, as it becomes due. We gave the defendants a gift and said instead of collecting rent until and including January 2021, we would accept the $15,000. They did not pursue any or present any argument. They are now saying the $15,000 is liquidated damages for everything. Since their position has changed, Your Honor, we would elect for them to continue paying rent for the remaining duration of the lease. Here's the proposed amended final judgment, making the changes, took out the double rent. We corrected the mathematical errors. If you like, Your Honor, we can go through it quickly.
Is this section you're showing me, the A 3.595, under the dwelling portion of the
Yes.
statute, or the
Yes.
non-dwelling portion?
It's the residential portion.
Is
However,
this parking lot, the casino?
yes, Your Honor, and the lease says we're entitled to chapter 83. It doesn't state in the lease, it's just section 11, that we're only entitled to the non-residential portion. It says chapter 83, so we're entitled to everything in chapter 83.
Do you have any cases that say that by a commercial lease referring to chapter 83, it turns it into a residential lease?
No, Your Honor. Your Honor read this during the trial and concluded that, yeah, we're entitled to, and Your Honor states in the transcript, we're entitled to wait, collect rent as it becomes due, or $15,000.
Okay. Well, I'm not sure at the time I was aware of the dichotomy between the commercial section and the residential section of the statute. It seems to me, knowing that, there would be the commercial portion of the statute, which may call for something similar and it has to deal with forward rent somehow. What does the commercial section of the statute say about this issue?
It doesn't, Your Honor. Also, the lease states that they are to continue paying rent until and including January 2021. We gave them a gift and now they're objecting about it. So we're taking the gift away and we've elected to let them continue paying rent until the end of the duration of the lease.
Where in the lease does it have that provision? Let me just do it.
Section 3 of the lease on page 3, it states the duration, allowing them to continue paying rent.
Okay.
So, Your Honor, the amended final judgment provides, Paul and I were I'll do the math. The final judgment had $3,500. It should be $3,503.18.
Okay.
We made the correction of the $3.18 as Mr. Caldwell requested in his motion on the final judgment, paragraph 24, now paragraph 20 in the amended final judgment. The paragraph 24 in the final judgment, which is now paragraph 22 of the amended final judgment, totals $14,860.96, not $14,860.90. It was a 6 cents error, so we made that correction as Mr. Caldwell requested in his motion. Additional $12.50, and if it's not paid by tomorrow, they owe another $700.63. All that is in the amended final judgment on paragraphs 31 and 32. Paragraph 33, they've been paying, according to the lease, 1/12 of the, back on October 30th, Your Honor, let me present a copy of the tax bill. The tax bill was not available Since October
Hey,
30th,
I object.
a property tax bill has,
What's your objection?
Well, it's not evidence, Your Honor, and file is over.
Okay.
since
You're
October,
offering this as evidence of this hearing?
yes, sir, actually under the lease, they are to pay the property taxes. It states that they're paying 1/12 of the prior year's gross taxes, which is an estimate. Now that we have the tax bill, we know exactly what they should have paid. If they would have paid 1/12 each month, we've now added that in on the prior paragraphs, the amended final
I
judgment.
reiterate my
Your objection is pending. I'm hearing Mr. Cinnamon's explanation pursuant to your objection.
They owe an additional $2,734.
Future rents and liabilities. I don't see how today I enter new amounts and make new findings. Those are accruing, let's say, under your theory, and you could sue for them again, let's say at the end of the rent of the lease period or something else. But adding them into a judgment after the fact in which no evidence was presented, and so let's say I cancel this hearing, and I don't know that that's appropriate.
Yes, sir, I was following on the transcripts on page 100. Your Honor states, it says that he can send a rent bill every month for the remainder of the term. So all I did today is, this is what the bill is as of today.
Based on your theory that you're changing your election, I understand, and if I accept that theory in the end, I believe that I can put in this judgment that such amounts are still due and owing. But I'm not certain that they were proven future amounts at the trial, and that they should be in this judgment as a collectible judgment. They'd be out there as accruing rents, but not reduced to a judgment form. This is my thoughts. Put a question mark at the end of this whole paragraph. You know, some of it doesn't sound like a question. So I see three possible alternatives. One is that we reduce this judgment to the amounts at trial with an annotation that future rents and other matters are accruing but not part of the judgment.
Yes, Your Honor.
The second part is, so that's one option. Second option is, this judgment doesn't mention the future. But that's like the court giving an advisory opinion. And you all deal with it in the future however you wish to deal with it.
B.
B of what?
Oh, in the amended final judgment on the
B of
first
what?
page.
B of what section?
First page.
In the summary.
On the amended final judgment, Your Honor. Thank you, Your Honor.
Anything else we should state?
No, Your Honor. All we ask is for a date on the ownership promise.
And the last thing I want you to respond to, that, although maybe we want to hear Mr. Cavill argue this point first. Mr. Cavill made the statement that it would be error to allow you to make a re-election at this stage. So actually, let's hear what his cases and law is in support of that, and I'll have you respond to just that. But let's just take a 5-minute recess before we do this part of the argument.
All right. Do you have a copy of the case that you signed? sent you this response almost 3 weeks ago. I don't know. I sent you the response almost 3 weeks ago. You know, you gave me your argument for walking in.
Mr. Cinnamon's argument? Have you seen that amended, proposed amended judgment before?
No.
Are you ready to respond, or do you need time to?
Well, I would need, especially considering the various difficulties we've had with the one that was entered first, I would like time to review this. I think it would behoove us to have the court make a ruling, and then with both parties to go back and try to encompass that ruling in a proposed amended judgment 1 through 2. So I do have one case that I came up with today.
Please.
Case is Arby versus Villeneuve, B-A-R-B-E, B-I-L-L-E-N-E-U-B-E. Mr. Cinnamon's argument rests on shaky ground, especially in light of the double rent request, which was improper, and the accelerated rent, which is improper. They persist in that argument. First of all, it appears that here in open court, Mr. Cinnamon is making Ori Tennis motion to undo an election of remedies. I submit that that's improper. I object to it. I object to the court moving forward with that on the ground that he did not submit a motion. Furthermore, the court found that Mr. Cinnamon, on behalf of his client, the plaintiff, made the election of remedies. That determination is a factual finding. Factual findings are not up for debate this time. Under this case stands, that I just handed Your Honor, it stands for several propositions. Well, and I would add that the first time this idea that the plaintiff would like to undo its previous election of remedies, first time that came up was in the response to our motion to alter the judgment. In that response, not a single statute or case is cited for the proposition that the plaintiff may do so this time. Under this case, and I really just submitted this case because it touches on black letter law pertaining to election of remedies. I am on the third page of the printout, which I believe is page 1332 of the opinion, where the Supreme Court states that the election of remedies doctrine is an application of the doctrine of estoppel and operates on the theory that a party electing one course of action should not later be allowed to avail himself of an incompatible course. Flipping the page on the handout at head note 1 and 2. The Supreme Court states that an election between legally inconsistent remedies, such as the ones we have here, as previously explained, can be made at any time prior to the entry of judgment. So the judgment has been entered, simply altered. So it's too late for a new election. They had their choice, they made it, they're bound to it, and they've provided no meritorious argument, and certainly no legal authority to support the contrary proposition. As I stated, they haven't filed a motion. Moreover, to the extent that they're seeking to undo a factual finding, they're out of time to file their own motion. The court doesn't have jurisdiction.
What factual finding?
The finding that the determination that an election that they elected a certain course under the contract is a factual finding. And I believe there was language.
The course that they elected, notwithstanding how you want to see it, the course that they elected was to obtain those liquidated damages in addition to back rents. How you want the court to define it today is not the election that was made at trial. If you want to stand on the argument, or the defendant wants to stand on the argument that an election was made, that election was back rents, and the $15,000 was liquidated damages for forward rents. And I can understand how you would be within your rights to insist that the plaintiff stick to that election. But when the defendant is the one that's redefined the election for the purpose of this motion to $15,000 in total which was not the election made at trial, then those are inconsistent.
The plan,
That's a sword and shield. I think, is that what they mean when they say using this as a sword and a shield? You're using it as a sword to reduce the overall damages from 50 or 60 something down to 15, and as a shield to say that they can't change that election now, it's too late.
well, it's not using it as a sword. I don't think the
Okay,
sword
throw out
and
the
shield.
sword and shield. I never really understood what that.
I don't think the sword and shield doctrine applies.
I don't think so. But I think that the election that the plaintiff had made at trial was to receive $15,000 in liquidated damages in lieu of future rents. That was the explicit election that was made.
To be sure, Your Honor, the election that's presented is governed by the language of the contract. The election is inherent in the language of the contract. despite what
But
it
if
says.
they're stopped from changing their election, it's the election that they actually made.
Moving on, even if such a thing were possible, we submit is not and would be erroneous. The argument offered that all of the residential remedies under Chapter 83 are available is simply untenable.
Untenable. I find that they're not available.
And agreed, and just to underscore, Your Honor, it says in particular in point 2 of that section 11 of the lease, it says lessor may pursue any remedies permitted. That key word was left out of the plaintiff's argument. Any remedies permitted pursuant to Chapter 83 or extension. And the ones that are permitted are the non-residential. I agree with your Honor's determination.
And that's the one that Mr. Simmons wishes to seek today. The one that's permitted. Continue to be paid the future rents. That's right in the contract. It lists a number of dates, January 2019 being the current law, in which the defendant is part of the footnote in this judgment, but the obligation seems to exist under the lease, and
And I disagree with that, Your Honor, respectfully, if only because Your Honor made the factual.
I don't know that I need to make that finding there, because I agree with you that I should not include those in the judgment, and then people will then, in the future, make the motions that they make, and I'll deal with the motion that
Simply to make my record on that point, Your Honor, one of Your Honor's factual findings was that the premises was surrendered.
Anyway, you don't have to make a record, because I'm gonna leave that open, that battle open for another day.
So, I think I covered all the points I wanted to make. There's been no motion. It's too late for a motion for a hearing. There wasn't a motion to undo the election of remedies. It's too late to undo the election of remedies. And even if it were not, the plain language of the lease does not permit acceleration of rent under the residential provisions of Chapter 8. I don't know if Your Honor has any other
Respond
questions.
to your argument here under Barbet that he would not be permitted to change his election of remedies, and then you'll get the last word based on whatever he says. Go ahead.
Thank you, Your Honor. Under Barbet, which Mr. Caldwell read, an election of remedies between legally inconsistent remedies can be made at any time prior to entry of the judgment The defendant's filing a motion to alter or amend the judgment tolls rendition of the judgment, which is why we're here today, several months after the judgment was entered. So we can still be made up until 15 days after the amended final judgment is entered. As to Mr. Cowell's other response, Your Honor, this amended final judgment, if I may approach, was handed to Mr. Cowell on December 14th, several weeks ago.
It's the same one that you handed me earlier?
Nope, the only difference between what I'm just handed, Your Honor, and what Mr. Cowell received on December 14th is I changed the date from December 2018 to January. On this amended final judgment, Your Honor, the mathematical corrections are made. The double rent is deleted, and it has the liquidated damages in lieu of accelerated rent for the $11,000. So,
Liquidated damages at 7?
for $11,000
Which liquidated damages?
on paragraph 11 of the lease.
I'm not sure now which one. Except the 8-page one is the newer one, right?
Yes, Your Honor. The difference between right, the 8-page one has rent accrued every month, and it's the paragraph A on the first page is $15,000 less than what's in paragraph A on the amended final judgment that I just gave you, Your Honor. So if we keep the $15,000 liquidated damages, it's the amended final judgment that I just handed Your Honor. It's only because of the change in the defendant's position now that we have elected to let them continue paying rent until January 2021, I'm sorry.
All right, fine. Okay. So, do you want to respond to that?
I do just a couple of points, Your Honor. I have not had a chance to review what's being proposed today. Again, I don't think that it's.
Okay, I'm not going to sign anything today.
Okay, thank you.
I'm going to make some oral pronouncements as to these issues, and then you can cut and paste this thing. Maybe you want to sit down and use this 8-page judgment here.
Figure it out. I just don't want anything to be done quickly and generate more mistakes like the first time the judgment got proposed. With respect to Barbie, however the case is pronounced, the term entry and the term rendition are terms of art. The judgment is entered when it is signed and submitted to the clerk. The judgment is rendered for appellate purposes. The rendering of the judgment is not, I think, almost never the same time as entry. When the Supreme Court says prior to entry of the judgment, that's what it means. It doesn't mean prior to rendition of the judgment for appellate purposes. So, Mr. Cinnamon's my friend's attempt to distinguish on that point, I think it's not well taken. And trying to remember if we had any other points that I wanted to address. I thought there was a third. Is there something else that Your Honor had a question about?
No.
Okay, well, thank you.
Okay.
With that,
So,
that the motion be granted.
I agree with the defendant's view that I had an incorrect application of the law to this contract. And allowing the plaintiff to recover all of the back rent and then providing a $15,000 liquidated damage portion in place of forward rents. That just is taking a residential portion and a commercial portion and a lease portion. So I'm going to throw that part out. Throwing that part out leaves the status quo as it was. I'm going to enter this judgment without these forward rents after the time of the trial. So that's basically taking out the section in paragraph B.
Do I understand correctly, Your Honor, that, that means the liquidated damages are
Yes.
coming out?
Liquidated damages are coming out. So I'm looking at this 8-page judgment that Mr. Cinnamon proposed today. And without buying into every line, I wouldn't mind if you all would have that debate today about little details in the language, so that we can try to settle that. But in terms of the concept, I'm going to allow all of this back rents and these different things, the towing, whatever that was, cleaning up the property, and some of these other things. Strike out the future rents, future meaning from the time of the trial. Strike out the $15,000. And that's without prejudice to any attempt that the plaintiff seeks to make in the future. I won't advise the plaintiff in what to try to do. If the plaintiff's view is that rent continues to accrue, the plaintiff can try to collect that rent in any way the plaintiff deems fit, and without prejudice to any defenses that the defendant wishes to raise to that collection of rents accruing from the time of the trial. Is that enough information for you all to mark up the judgment?
Yes, Your Honor.
I believe so, Your Honor. One point that it's minor, I believe we agree on it, that I didn't mention. We do want the altered judgment to state that the corporation, Metro Parking, which that was the lessee, that it be named as the,
It's already in paragraph D
Yeah,
on the
prime-
second page.
just to bring it to Your Honor's attention, that they're named as the primary judgment debtor, and Mr. Long, being the guarantor, is in the judgment denominated as secondarily liable since he's a guarantor. But it's already in there, I think we agree, I wanted to bring it to your attention.
Now, the plaintiff is seeking a hearing date or a rule to show cause why these defendants should not be held in contempt for failing to fill out the those judgments.
Your Honor, we can do that in, early next week. My understanding, I haven't had a chance to look at this. I am aware of the court's order. My understanding is that because this parking company has a lot of shuttles, some of the shuttles have been in, is my understanding from, some of the shuttles have been in the shop for repairs for an extended period of time. In order to get the registration and some of the other information for the vehicles that's required under the form fact information sheet, we've had to try to reach out and get a hold of those vehicles again in order to make it complete. My understanding is that basically everything except that has been gathered because of the holidays. They just have a couple of days. So they're trying to get that, filling out the juror, and we should be able to get it over there.
So, Mr. Campbell, I'm happy to give a hearing date for that after whatever time it is that you think that you need to provide the documentation so that the hearing date is out there as an incentive. How far out do you want the court to set the rule to show cause?
I think the defendants should have enough time to have until next Friday, if that's acceptable to the court. And then we could have the rule to show cause thereafter.
Okay.
Again, I anticipate it being quicker than that.
Okay, well, that's certainly, reasonable. Let's see. Okay. So our Tuesday the 22nd at 10 a.m. or Thursday the 24th at 2:30, these motion calendars, that's probably a good time to have it. Any of them, although if Mr. Campbell does not want to accept service of the rule to show cause, you're gonna have to serve it, so you're gonna have to have enough time to serve it. Mr. Sullivan.
For the order,
A rule to show cause has to be served on the defendants.
Thank you, Your Honor. The 22nd, I have it's going to be a very lengthy fee hearing in front of Judge Trewick.
Hopefully it's your fees.
It is.
Okay, good. We're not gonna get in the way of that.
Thank you. The 24th looks clear to me, Your Honor.
Okay. Will you accept service of your rule to show cause from the plaintiff?
Because it would save the cost that they're entitled to
Your Honor,
required to pay.
I think it would only be collegial of me to do so under the circumstances.
Okay. So how does the 24th at 2:30 look for you, Mr.
Fine, Your Honor.
Okay, great. Anything else today on this matter from you?
Your Honor, we also asked, on the amended final judgment, would Your Honor like any language as to future rent in the judgment?
I'm not going to enter any language about future rent. I'm going to leave that open for you to seek whatever you wish to seek in any manner that you wish to seek it in future rent, and for the defendant to defend that attempt in any way. I don't think that I should short circuit either party's
May I respectfully request that we just have it that the plaintiffs may be entitled to future rent and that the defendants may assert any defenses that they have to future rent.
My position is that would be an impermissible advisory opinion.
Okay, I agree, but what I don't want to do is relinquish jurisdiction towards any entitlement that the defendant may have. It may be that the defendant may not have, that the jurisdiction might not lie best in this action. It may be a future lawsuit that can be filed anytime, say like at the conclusion of the lease period.
Respectfully, Your Honor, I'm not sure that is appropriate because I have a feeling that if such language regarding the reservation of jurisdiction would be included, it may render the altered judgment non-final.
The court often retains jurisdiction, or already has retained jurisdiction to award attorneys' fees and costs.
I don't want to issue an advisory opinion, but I do want to reserve jurisdiction. Mr. Cinema, what language do you propose?
Just the court reserves jurisdiction as to award entitlement of future rent.
I know that you object, because you don't want to pay, among other reasons, that you don't want to pay any future rent. So, is there anything about that language, besides the fact that it potentially is not helpful to your client? Is there anything about that language that you object?
You mean the form of the language,
The
Your
form
Honor,
of
as
the
opposed
language.
to the substance?
I want some language that allows Mr. Cinema to file his motion for you to defend. I don't want the language to surrender any of your defenses.
As long as my objection to all of that is noted. Perhaps the easiest way to do it would be to have the parties submit proposed altered judgments.
It's just a sentence. I want to decide the sentence now while everybody's here.
I would prefer to have some time to think about it just because my brain is a little fried at the moment, Your Honor.
I'm sorry, but we need to decide it now so that we don't have other hearings and 10 emails that have to go back and forth, etc. However, Mr. Cinema, would you write down the language that you propose and hand it to Mr. Capel, and let me address Mr. Fowle and Mr. Harrison here at the podium while you all work out some language issues. So we'll go off the record again.
Just before we go off the record, it just seems confusing to me, Your Honor, because it sounds like the court is resolving the claims that were pleaded, and yet intending to have further proceedings and perhaps another trial on claims that were not pleaded separately and that were resolved in the original trial.
And I want you to be able to respond to any future motion that the plaintiff says, and to say that this is res judicata, that it's improper, and there's no reason. And Mr. Cinnamon should be able to come back and say, but then you see here it says the court reserved jurisdiction. So the court admitted that they were going to have this hearing. I don't know if the hearing is appropriate.
I don't think it is, and I think that since the court is not convinced either, that it's not a,
I don't know if it is or if it isn't.
perhaps not a prudent inclusion in the alter judgment.
Anyway, Mr. Cowell, I understand that your tactical desire is to keep out the language. And that you object. And without waiving your objection, I wish for you to participate. I'm going to put in some kind of language like that. I would like for you to have input in the language so that it doesn't, if I'm not the judge and somebody else is looking at it, let's say none of us are here, and then the plaintiff's attorney argues, see, it said right here that the judge was retaining jurisdiction to have this hearing on the January and the February rent, and that's not the case. I don't know whether I should or if I shouldn't. So the language should reflect that I'm not taking a position on it.
Thank you, Your Honor.
Thank you. Okay.
Mr. Collins and Mr. Patterson, good afternoon to you all.
Good afternoon, Your Honor.
Do you want to use the table since you have that?
Yes, please.
You can use this table right here, since you have that big computer.
Thank you for all the extra time.
Oh, you're welcome, sir.
Your Honor, this is for you.
Thank you.
You're very welcome.
Is that the same as this one?
Yes.
Yeah, so I already had it. We're here on the record in the matter of Omar Fawad versus the city of Miami. What's your name, sir?
Omar Mohsen Ibrahim Fouad, Your Honor.
Mr. Fawad, are you representing yourself?
Yes, Your Honor.
I'm representing the city of Miami.
Douglas Harrison on behalf of the city manager.
Good afternoon to you both.
Good afternoon, Your Honor.
Mr. Fawad, have you had a chance to speak with each other about what we're trying to accomplish today?
Briefly, yes.
What are we trying to accomplish today, Mr. Fawad?
Well, today I'd like to present evidence. I'd also like to make it aware, once again, that I'm willing to settle outside of court. But I'd like to give this case the justice it deserves, being that people have lost their lives in the past due to police brutality. Specifically, 2 young men from my neighborhood in Pompano, where I grew up, where I was born and raised, they lost their lives due to police brutality. So I feel like this case deserves the justice it deserves before we take the necessary measures to settle outside of court or to settle in court.
Okay, and how long does it take?
This CD-ROM, this DVD-ROM rather, contains about more than 100 files. Some of them are pictures. Some of them are evidence of. It's gonna be pictures of the injuries that I sustained due to the police brutality caused by Officer Rania Rodriguez of the City of Miami Police Department. There are files in here that indicate the research that I had to do, all of the difficulties that I experienced to try to bring this case to the attention of the proper people like yourself, Your Honor, and people like the director of the police department here in Miami, Mr. Juan Perez.
And how long is it?
Excuse me, I'm a little nervous, Your Honor.
It's not a film, it just has files.
Yes, Your Honor.
He does have a video of the incident.
I have a video of Officer Ronnie Rodriguez after he, with his two fingers, his pointer finger and his middle finger, poked me in the middle of my chest, shoving me backwards. I have a video of him right after he did that, and I specifically started recording him because he did that. And I asked him for his name because I was going to report him for doing that specific thing. Now, also, before he started poking me, immediately after he started poking me in my chest, I raised my hands like this, and I said, "Sir, could you please just call your sergeant?" He then immediately walked away from me, turned his back on me rather, and walked away from me. I then started recording him because of the fact that he started shoving me in my chest after my mom clearly texted me telling me to call the police after I explained to her that my life was being threatened. Officer Ronnie Rodriguez just so happened to be in front of Publix where I was going to buy dinner for myself that night after my life was threatened. Now, I specifically approached Officer Ronnie Rodriguez very respectfully, and I clearly asked him if I may approach him because his back was to me when I approached him. Now, specifically, I asked him if he could help me file a police report and report the matter of my life being threatened. And I also explained to him that I contacted Morgan & Morgan, a law firm that actually reached out to me through Facebook because of videos that I was posting online while I was working at a very dangerous area here in Miami. They sent me messages in regards to unpaid wages, unsafe, unsecure, unhealthy work conditions, and so many different things that they observed from my Facebook page. I hired them in regards to these matters, and shortly after I was threatened to the point where I had to leave my job because threats were being made on my life. Now, specifically, I reached out to my mother because that was my only means of being able to pay my rent. And my mother told me immediately to contact the police, to inform the police of that, which is what I did. And that is when I approached Officer Ronnie Rodriguez. Now, specifically, when I approached Officer Ronnie Rodriguez, he was hesitant to help me, but he did call my mother for me because I specifically told him if he could please call my mom to explain to her how serious this situation is. He called my mom from his cell phone. She didn't answer the phone. Now, specifically, someone pulled up behind him and me. The front of his vehicle, as you can see in the video, was facing the street and was parked somewhat into the street off the sidewalk. Now, he turned around. He had his back to the front of his vehicle and the back to the street, conversating with me. Now, specifically, I was facing the front of his vehicle. Someone pulled up behind him and started recording us talking. And I'm explaining to you this in detail, Your Honor, because I would like for you to know every single detail that happened, and I don't want anybody to try to fabricate the facts. Now, someone pulled up behind him, and in fear for myself and in fear for Officer Ronnie Rodriguez, I said, "Excuse me, are you recording us?" Speaking to the person who pulled up behind him in the vehicle with his phone clearly like this. Not like this, as if he was on a phone call, like this, as if he was recording us. Now, specifically, I said, "Excuse me, sir, are you recording us?" Officer Ronnie Rodriguez immediately turned around and observed the individual, then turned around and looked at me and said, "Hey," with his two fingers, started poking me in my chest, shoving me backwards, said, "Hey, don't tell nobody not to record us." I immediately put my hands in the air and I said, "Sir, could you please just call your sergeant?" He then walked away from me. I then pulled out my cell phone and started recording him, asking him for his name, because I was going to report the fact that he did that. Now, specifically, when he saw me recording him, he then turned around and started acting as if he was concerned. And he confirmed the fact that I asked him to call his sergeant, because he specifically said, very sarcastically, and if you were to ask me, I would say it was very rude. He said, okay, yeah, you want me to call a sergeant for you? I'll call a sergeant for you. You can keep recording all you want. His sergeant arrives, Your Honor. Sergeant Edwin Gomez. When Sergeant Edwin Gomez arrives, he asks me, I explained to him exactly what I explained to Officer Ronnie Rodriguez, that I needed his help to file a police report because of how serious the situation is, and I continued to explain to him that I already hired an attorney, law firm by the name of Morgan & Morgan in regards to the life-threatening situation that I was suffering from.
Who was causing the life-threatening situation? Not the city of Miami.
No, Your Honor, but
I understand.
yeah,
Another situation.
customers in the city of
Whatever.
Miami at the store.
Yes.
If I could describe to you the type of customers, I would have to
No,
say,
that's a separate issue. That's nothing to do with
I would have to say very ignorant drug addicts.
it. Okay, that's fine.
Unfortunately, that's the type of customers you have when you work at a convenience store in the middle of the ghetto. Regardless of that, Sergeant Edwin Gomez proceeded to file the police report for me because of how serious the situation was and because of exactly what I explained to him. Now, specifically, Your Honor, I continued to explain to Sergeant Gomez what his officer did, and it went from what's the word? It went from a conversation of absolute concern to, you have 3 seconds to leave. Sir, I really need your help. I'm not trying to be difficult or upset you. I'm
Talking to me or
talking
to
to Sergeant
Okay.
Gomez. That's exactly what I told him. I said, sir, I'm not trying to be difficult or anything. I honestly need your help. Someone honestly is making threats on my life. He said it again. He said, you have 3 seconds to leave. I said, sir, with all due respect, please, I really need your help. He said it again. You have 3 seconds to leave. And then he starts looking around. When he starts looking around, I felt hopeless, Your Honor. And I wasn't the slightest bit disrespectful when I said, sir, if you're honestly going to threaten me and tell me I have 3 seconds to leave when I have the legal right to ask you for help, then 1, 2, 3. And my hands were on my side. When I said that, Officer Ronnie Rodriguez put me in a chokehold. Choked me to the point where I couldn't breathe, and I fell to my knees. And I'll show you the evidence of the injuries on my body. When I fell to my knees, I said I couldn't breathe 5 times. Each time I said I couldn't breathe, my voice was less and less loud. Specifically, I can't breathe. I can't breathe. I can't breathe. I can't breathe. 5th time I said I couldn't breathe, Your Honor. He violently twisted my neck to the right. My body then went limp. But I was still awake, but my vision went blurry instantly. When my body went limp, he felt my body go limp. He then picked me up into the air from his side like this. When he picked me up, he picked me up from my left side. When he picked me up, the entire left side of my body grinded against his duty belt. And I'll show you, I still have scars on my body from that. Now, he then put me in handcuffs and took everything out of my pocket. And he put the handcuffs on me as tight as he could put them on me. And he put me in the back of the police car. As soon as he put me in the back of the police car, Sergeant Gomez leaves. And then the PRI officer, Officer Leslie, approaches him with another officer smoking cigars, big cigars. And they immediately approached him and asked him, they did just like this. He said, so why'd you beat him up? And I was watching them conversate from the inside of the back seat of the police vehicle. And Officer Leslie specifically was standing right next to the window of the vehicle. From what I seen was so I could hear him speaking to Officer Ronnie Rodriguez. When he asked him specifically, why did he beat me up? Officer Ronnie Rodriguez looked at him in awe, in shock, as if he can't believe, as if he couldn't believe that he was asking him that question. Now, Officer Leslie, then, from what I seen, he cross-examined him. He then noticed immediately that he became fearful of the fact that he was asking him that question. So he then became, he started to befriend him, to become as if he was on his side. They sat there and made comments back and forth to the point where Officer Ronnie Rodriguez believed him, to the point that he believed that he was on his side, to the point that he stated, man, let's just take this kid somewhere and beat the shit out of him some more. He stated that, Your Honor. And I was sitting in the back seat of the vehicle scared for my life, thinking that they were going to end up killing me. Now, Officer Ronnie Rodriguez then came to the left side of the passenger, the back seat of the car, opened the door while Officer Leslie was still on the right side of the window. Officer Ronnie Rodriguez opened the door and was leaning into the vehicle looking at me very aggressively, very angrily. He said, the next time a sergeant tells you to do something, you do it, or you're going to get your ass beat. I said, sir, with all due respect, that doesn't justify the fact that you just brutally assaulted me. When I said that, Officer Leslie said something to Officer Ronnie Rodriguez, and Officer Ronnie Rodriguez slammed the door in my face. Then, he took me to the hospital. When he took me to the hospital, he was leaning over the back seat of the vehicle in front of the door for the psychiatric unit of Jackson Hospital, filling out some kind of report. Now, mind you, when he was filling out that report leaning over the back seat of the vehicle, I was watching him the entire time to make sure that he didn't destroy my phone that had the evidence that I recorded. While he was leaning over the back seat of the vehicle writing the report, there was about 4 or 5 seconds where he just dropped his head. And it looked like in a shame, or in, feeling bad for what happened, for what he did. He then was, I guess, documenting my belongings, my property, and when he looked at my hat, I have a hat from the Will Smith movie Suicide Squad. And it has like a bullseye on it with several characters of the movie. And he commented, he said, oh, people are probably trying to kill you because you have a bullseye on your hat. He brings me inside the psychiatric unit, Your Honor, in handcuffs. He then takes the handcuffs off of me and he leaves. I immediately asked to speak with a doctor in regards to the injuries that I sustained and because of how much pain that I was in. The doctor comes out, very sarcastically looks at me and stands over me and says, oh, you have to wait. As if he was implying that I have an abundant amount of drugs, in a sense, in code word, so to speak. Which really bothers me, because I don't sell drugs, and unfortunately, I'm suffering from PTSD, anxiety, and depression, and the best medication to prescribe for someone suffering from what I'm suffering from is marijuana, something that they consider a drug. The doctor then stated that I have to wait. So I very patiently waited. I sat down very quietly, holding my neck in an excruciating amount of pain. About an hour goes by, and I'm watching the doctors and the nurses, and they're not doing anything. They're just like, they weren't doing anything. In the sense of, trying to help me. So I asked them again, and the doctor says the exact same thing. He says I have to wait. I then pick up the phone and called 911, Your Honor. And I explained to 911 that I was just brutally assaulted by Officer Ronnie Rodriguez for no reason whatsoever. And I explained to them that I am the son of a retired Broward Sheriff's employee. And I explained to them my father retired from the Broward Sheriff's Office after 30 years. And that my mother is a school teacher. And that I have a 10-year-old daughter. And that I have several injuries on my body from police brutality, an intentional aggravated assault committed by Officer Ronnie Rodriguez in the presence of Sergeant Gomez. They immediately asked me, where is my location? I explained to them, I then asked the nurse what the exact address was. The nurse then told me what the address was. I then explained to the 911 operator what the address was. She said, do not move from your position. We are sending rescue to you immediately. As soon as rescue walked into the door, I was still standing on the phone holding the phone. As soon as they walked into the door, I immediately started walking towards their gurney to sit down on their gurney. As soon as I was about to sit down on the gurney, all the doctors and the nurses and the staff members came out of the rooms that they were in, and they just started to cause it was like a really deceitful, organized situation of just disarray, and said, no, you guys can't, you guys have to leave. You guys have to leave right now. You can't help him. I was then in even more fear for my life. Now, as soon as the rescue left, I felt as if that was it. I'm never going to be able, they're never going to let me out of this hospital because of what they just did to me and the fact that I'm attempting to report them. The next thing they did, Your Honor, was they came out with a needle about this long, and they said they were going to inject me with something that was going to help me relax. I clearly said, I'm relaxed. I need to see a doctor in regards to my injuries because I'm in a lot of pain. They then said, no, you have to relax. You have to relax. I said, I'm talking to you perfectly calm. I'm relaxed. I was actually talking to them more calm than I'm talking to you right now, Your Honor. Now, they then surrounded me with 10 people, forced me into a small room, told me to pull my pants down. I said, excuse me, what are you attempting to inject me with? They wouldn't even tell me what it was that they were injecting me with. So I then asked them if what they're injecting me with, is it going to kill me? They said, oh, no, honey, no, don't worry. So, being that I was surrounded by 10 people, and the more they said that just turn around so we can inject you, the more aggressive they became. So I felt as if I had no choice, as if I was being sexually assaulted, Your Honor. And I don't like that, because when I was a little kid, I was sexually assaulted by my stepfather. Now, specifically, they injected me and I fell asleep within 30 seconds. And before they injected me, I said, okay, inject me in my rear end, but please don't close the door. They put me in like a little room, like a cell. And I said, could you please leave the door open? They said, of course, we'll leave the door open for you. I was convinced they would leave the door open. I then let them inject me. As soon as they injected me, I turned around, standing in front of the bed. The person who injected me walked out, stood in front of the door, turned around, and then slammed the door in my face. I then woke up hours later, Your Honor, and they brought me upstairs, and they said that that's where I was going to be housed or evaluated. So I asked them, how long am I going to be, how long do I have to stay here? They said, until the doctor sees you. It's okay. I immediately noticed that the nurses and the staff members and some of the people who appeared to be patients in the hospital were working together to try to cover up the police brutality in several ways, Your Honor. First, they tried to stir up unnecessary arguments with me, just to make me seem like if I was a bad person, to obviously benefit the police, or whatever defense the police would try to use. Now, which is very common in these types of cases, Your Honor. Now, I knew what they were doing. I mean, I come from Pompano Beach, Florida. You know, I'm familiar with having to, you know, having to decipher, you know, good people from bad people all the time, especially when people are trying to conspire against you deceitfully and frame you, in a sense. Now, I knew what they were doing. It was obvious. And I then contacted 911 again because I was in that much more fear of my life. When I called 911, I explained to them that this is the second time I called 911. And the first time I called 911, they told the rescue team that they sent to help me to immediately leave the hospital. And I've been in the hospital now for 2 days against my will, suffering from several injuries on my body from the police brutality that Officer Ronnie Rodriguez committed. They said the same thing. We're sending, no, this time they said they're sending Internal Affairs to the hospital. When Internal Affairs came, they immediately took pictures of all the injuries on my body, documented everything. And it wasn't until then, Your Honor, that when the Internal Affairs brought to the attention to the doctors that I have several injuries on my body that are clearly from an aggravated assault, and that I'm suffering from several injuries, and I'm in an excruciating amount of pain. It wasn't until then that the Internal Affairs said that to the doctors, that the doctors immediately scheduled for me to get an X-ray, an MRI, and a CT scan of all of my injuries that stem from the top of my brain, down the left side of my face, down the left side of my neck, down the left side of my ribs, down my left leg to my left foot. They then made me stay at the hospital from August 8th to August 17th. The police brutality happened.
Is there anything that you want me to do about this today?
Your Honor, I would like to present to you all of the evidence that I have.
You just presented me all the evidence. Mr. Folak, what is the purpose of you presenting the evidence to me today? What is it that you want?
I would like to start a jury trial, Your Honor, but I'm not exactly...
That will be your testimony at the jury trial. I am not the jury, and so, Mr. Harrison, has your motion to dismiss been adjudicated yet, the one you filed on November 9th?
No, Your Honor. I just went ahead and answered the.
Oh, you answered, so it's resolved.
It's resolved.
Okay, fine.
Your Honor, may I...
You want me to set your trial, case for jury trial?
Yes, Your Honor, but
Do you
before...
have any additional discovery that you need to do?
Yes, I'd just like to bring this evidence to your attention while we're here.
How much more time are you requesting, Mr. Folak?
I believe we scheduled this hearing for...
You schedule it for an hour and a half. You can schedule it for 15 hours if you just want to talk, and that's fine. But
well, I don't want it to be a burden.
I'm sorry.
I don't want it to be a burden on anybody, Your
Mr.
Honor.
Folak, if we're accomplishing something, it's not a burden if it takes 15 hours. if we're not accomplishing anything, if we're having a conversation, then the taxpayers don't want to fund that if it costs 15 minutes.
I understand. I'm
We
willing.
have to be accomplishing
I'll pay for it.
something to move the case forward to a resolution. Is there anything that you need from the way this case, Mr. Harrison, on behalf of the city, has now answered your complaint?
Okay.
The case now is in the discovery phase.
What I need, Your
You
Honor.
need information from the city, or if the city needs information from you, that's what we need to do now. I see some subpoenas in the record. I don't know, that was you subpoenaing the medical records, I assume?
Yes, sir. Yes, Your Honor. What I need specifically is a peace of mind and some closure. You know, I'm not able to sleep at night. I'm suffering even more now from insomnia. And as I stated, I suffer from PTSD, anxiety, and depression. I'm up all night, every night, doing research, watching nonstop cameras in court, Supreme Court cases of civil rights violations. And it's just, it's really ruining my life, in the sense of me being able to function properly and do what I need to do in life. You
What is
understand?
ruining your life, Mr. Fawad?
The fact,
This court case or
no,
the
the-
injury that
the-
you incurred
the
some
fact-
time ago?
both and the fact that the defense counsel for the City of Miami Police Department, who was defending a criminal, an officer who brutally assaulted me, who violated his oath, okay, is under the impression, because we have not had this conversation yet in depth as we have today, and I haven't presented all of this evidence in front of him, he's under the impression that I've caused these injuries to myself. And that is a problem, because that puts me in even more fear than I'm already in. Because based on what the law says, if you lie about a police officer brutally assaulting you, you can go to jail for the rest of your life. And I'm not going to lie about something like that, Your Honor. I have a 10-year-old daughter. My son just recently died from medical malpractice, okay? My son's mother has a multi-million-dollar lawsuit in medical malpractice court in Broward County because of the fact that my son died due to the negligence of a hospital, 2 OBGYNs, a doctor, and a healthcare company, and a registered nurse. Now, I'm already suffering from PTSD, anxiety, and depression because of that. This has increased my level of PTSD, anxiety, and depression. My family, Your Honor, is scared.
Mr. Fawad, let me explain to you now how this matter will proceed to be resolved.
Yes, Your Honor.
And you can direct me in some of these matters about how it can be resolved. Because I certainly am sympathetic to the anxiety and stress that the court case, in addition to whatever happened in the incident with the police officer, that the court case can cause, especially to a vulnerable individual representing himself. The normal way that a case like this would go is that once discovery was completed, exchange of information, it would be placed on a trial calendar. A case like this, which is relatively new, ordinarily takes some long period to get ready for trial. On the day of trial, a number of individuals who would be potential jurors will come into the courtroom, and you, representing yourself, and Mr. Harrison, representing the city, will have to go through a jury selection process and select a jury for the case. Presumably, then, if you're going to do this, you should come to the courthouse and watch juries be selected in other cases so that you get an idea of what it's about.
Yes, Your Honor.
Then the jury will sit there and you will sit over here under oath, basically, and testify to the things that you testified today.
Yes,
And
sir.
you'll print out from the disc the exhibits that you want to show the jury. And Mr. Harrison will ask you questions. Do you then have any other witnesses that you wish to call?
Yes.
Who are your witnesses?
The narratives, the reference photographs from the internal affairs. When
Any
they,
other people that you wish to call as witnesses in your case?
yes,
Besides you?
yes, the reference photographs from the narratives of the internal affairs report,
Those
as
are
well as
exhibits. Any other people besides yourself that you wish to call? You'll be able to show the jury some exhibits during your testimony. Are there any other people that you are going to call?
Unfortunately, Your Honor, the vehicle of the police department, they can't afford, at the time they couldn't afford to equip the vehicles with cameras and
In any event, that
or
wouldn't be people.
and or
Are there
body
any
cameras.
other people that you wish to call? No, that's fine.
Yeah.
You're going to tell the jury your story.
Yes, Your Honor.
Afterwards, Mr. Harrison.
Excuse me, I'm sorry, Your Honor. In the video where I recorded Officer Ronnie Rodriguez, there was a witness. There was a gentleman who was living in the apartment building, on the same property of where Officer Ronnie Rodriguez intentionally, aggravatedly assaulted me, who came outside and sat down and watched the entire incident. And you can clearly see him in the video when I recorded. He had on a bright red shirt, and he sat right there and watched everything. Now, I went back to that apartment building, and I talked to just about every single resident in that apartment building, and they all pointed to apartment 1, the apartment that he was standing in front of. And they said that that is the spouse of the woman who lives in apartment 1. Now, every time I go to apartment 1, Your Honor, the lady, she's clearly aware of what happened. Someone's obviously brought it to her attention, and she just acts like she wants nothing to do with the situation, and she acts as if she doesn't understand English at all. Not trying to judge her negatively, but it's pretty easy to decipher nonsense from realistic, factual situations. Now, on top of the fact that, Your Honor, everywhere I go in Miami, I'm being harassed. When I go to the gym, when I go to Publix, when I go to do physical therapy, when I'm, I'm constantly being harassed, Your Honor. And the second that I bring it up, and the second that I bring it to somebody's attention, they try to pull this card as if I'm just completely insane and I don't know what I'm talking about. Now, it's common for the people to do that. Go ahead, I'm sorry.
I cannot be responsible for all of the problems that you have in your life. I'm sorry to hear about your son.
Well, Your Honor, it's a cover-up, Your Honor. That's what it is. And I have evidence proving it. So it's a citywide cover-up, and the majority of the people who are doing it are police officers' friends, Your Honor. And I have evidence proving that. I hate to say that in court because it makes the city of Miami-Dade County look corrupt. Something that Sergeant Edwin Gomez clearly stated on the Leo Affairs chat, stating that the Miami Police Department is corrupt.
Fine. Mr. Harrison, what month should I set this cause for trial?
I would ask we set it in the summertime, Your Honor. Your Honor, if I could, just with regard to this motion, this is plaintiff's motion to enforce judge's examination of evidence for jury trial. I'd ask that it be denied.
Okay.
It's,
I think we accomplished the purpose
Yeah.
that Mr. Fawad had today. He wanted here in open court to bring the court and the defendant to be aware of the seriousness of the allegations that he's making.
we take it very seriously.
Thank you, Mr. Harrison. I really appreciate you saying that.
Has accomplished his purpose. We then will.
And Your Honor, if you don't mind, if I may, ask the court if we could try to do this in, not too much of a gap of time frame, only because I suffer from memory loss because of the years of trauma that I've been suffering from. So I forget things very easily. And I don't want to wait several months and then come back to court, and then, I'm not able to focus entirely on the case because I've forgotten things. And I'm not in a position right now, unfortunately, because I'm in poverty status. I'm not in a position to be able to afford the proper equipment to make sure that I'm recording everything properly, documenting everything properly. I'm literally working off of 4 old, outdated cell phones and borrowing my roommate's computer.
Well, Mr. Fawad, you're claiming damages for injuries.
Yes, Your Honor. I'm claiming compensation for damages for injuries, pain and suffering, mental anguish, defamation, and every single thing that an expert attorney, if they were to look at this case and see exactly what I went through, exactly what they would say. Not just what I would say, because I don't know all the legal terms yet. I'm still reading the dictionary, the legal dictionary.
What the defendant is going to try to do is to gather all of your medical records and to have those medical records reviewed by doctors that they hire to evaluate the claim. And that's going to take months to happen. In many other cases, it takes years to happen.
Doctors that they hired, Your Honor?
Yes.
Okay, let me, if I may,
Not
doctors at the University of Miami Hospital, every time I go there, they did the same thing. They try to cover up the police brutality. They give me wrong information. They try to downsize the severity of my injuries because of the fact that I'm in the city of Miami suing the city of Miami Police Department. That's why I have to bring that to your attention, Your Honor.
I can't predict the future, but the doctors that they hire, if it's like in other lawsuits, are also going to try to explain why your injuries are not that serious. I'm just guessing that might be the case. That's what happens with these doctors in these cases. But the point is...
But that's if the injuries are not that serious. Mind you, Your Honor, I have a lipoma tumor in my neck that could be possibly cancerous, that has grown double in size, and the pain is now radiating from my neck to the top of my brain and makes the entire left side of my face warm because of the fact that Officer Ronnie Rodriguez choked me and twisted my neck.
And Mr. Fawad, where are you being treated for that?
At the University of Miami Hospital.
Okay.
Your Honor, if I could. Mr. Ibrahim Fawad was Baker by City of Miami Police. Parts of the video he has, because he took it on his phone, and he got his phone back, and they took him to a University of Miami hospital where he was treated, and they gave him his phone there, and he was able to take pictures and document everything. I'm just asking that this motion be denied, as in the pictures that he has presented to the court, what he's trying to do is get all his evidence in for trial, what he wants in. He takes a lot of pictures at the library of pages upon pages upon pages of legal books
Investigative research.
and publications. I would just ask that this motion be denied. I would tell the court so that Mr. Fowle can hear. I'm going to be asking for some of our doctors to evaluate him for his physical ailments, in the sense of any bruising or strains, etc.
And this lipoma.
And the cancer issue, the oncology issue, as well as a mental health screening and evaluation through one of our doctors, just for his PTSD, etc. Because there may be other issues there that could or could not have been caused by this incident.
And I'm trying to explain.
I did nothing but ask them for help, Your Honor. Now
Mr.
that bothered,
Fawad, Mr. Fawad,
Your Honor,
Mr.
if
Fawad.
I may.
No, if I...
Go ahead.
Sir.
Yes, Your Honor.
I don't need to hear today any more about the case. Because you're not an attorney, I want to use the time we have together to explain to you the procedures that we're going to use to resolve the case.
Great. May I, Your Honor? The motion should not be denied, Your Honor, specifically based on a biased opinion of someone who is defending a criminal.
The motion...
Your Honor.
No, thank you. Okay, thank you. The motion is not, in fact, a motion. it is neither going to be denied nor granted. It doesn't request any relief from the court. The motion is going to be construed by the court as a case management conference. That's what we've done today, is learned about the case and dealing with setting future matters. It doesn't require it to be denied or granted.
The city has no objection, Your Honor, if the motion is taken as case status conference or motion.
Your Honor, I was brought to Jackson Memorial Hospital Psychiatric Unit against my will. When an officer...
Mr. Fuller.
Yes, Your Honor. I'm trying to show you the corruption, the amount of what they did, the extent of what they did to try to cover it up.
Mr. Fuller.
Yes, Your Honor. Your Honor, when an officer brings...
Mr.
Go ahead.
Fuller.
Yes, Your Honor.
You have to now stop speaking and listen.
Yes, Your Honor.
It is my job to shepherd this case to a conclusion. You want it concluded quickly so that your memory will be fresh. The defendant has the right to have you examined by their own doctors and to obtain your medical records.
Have me examined against my will or
Yeah.
willingly?
If you decline the examination,
Uh-huh.
then the case will be dismissed and they will not be able to have the examinations. When you enter into a lawsuit to win damages in response, then you subject yourself to independent medical examinations called IMEs by the defendants. If you do not wish to have the IMEs, then the case will be dismissed and you won't have to have them. You won't be compelled against your will. It's not like a Baker Act or a psych eval in a criminal case. To bring this case to a conclusion, you will have to be examined, and then the defense will be able to offer that evidence. It is my job to bring the case to a conclusion. One matter of conclusion in the case is if you decide it's not worth pursuing and you dismiss the case. Another area of conclusion is if you all come to an agreement and the court dismisses the case after you all come to an agreement. Another is to have a non-jury trial, that I hear all of the evidence in the case and render a verdict, which we could have almost done today. Another is to have a jury trial. That's much more complicated for you. You'll have to select a jury. There'll be jury instructions and a lot of legal issues, etc. These are not decisions that you have to make today.
Well, Your Honor, I don't want to do anything that is going to end up becoming a burden on me only because I'm trying to exercise my legal rights when I have clear and convincing factual evidence proving that I was brutally assaulted by Officer Ronnie Rodriguez and all I did was ask for help. You understand, Your Honor? And specifically, when an officer brings someone to a psychiatric unit... Yes, Your Honor. Sorry.
Repeating the facts of the case is not necessary. It will not help us in bringing the case to a conclusion. I know that you feel emotionally serious about the case, which I don't. I'm not emotionally involved in the case. I'm professionally involved.
Right.
However, and I know that you're not a trained attorney, this is a case management. It's my opportunity to tell you what you need to do to bring this case to a conclusion. I don't need to hear any more about Officer Rodriguez or the doctors at the University of Miami or Jackson or anything else today. If you want the case to be resolved more quickly, then you can drop your demand for a jury trial and discuss it with Mr. Harrison, and we can have a much more quick non-jury trial, which you can present all of your evidence without the need for as much legal work.
Could we do that today?
Mr. Harrison still has the right to have you examined, and we could probably do it in a few months.
Okay. Your Honor, with all due respect, when an officer brings someone to the psychiatric unit of the hospital, they're not required to write a report. Now, Officer Ronnie Rodriguez specifically brought me to the psychiatric
Thank you,
unit.
sir. We're recessed for today. Good luck to you, Mr. Fawad.
May I say one thing?
No, you're just venting now. You're just talking.
No, the
and
reason-
I think we've accomplished all we can accomplish today.
No, I'm
that's
leading
all-
up to.
Mr. Fawad, that is all we can accomplish today. Thank you, Your Excellency.
Why is that, Your Honor?
Because we're no longer accomplishing anything. You are venting your emotional feelings and describing to me the facts of the case.
Okay.
And respectfully, sir, we are in recess.
Your Honor, is it wrong for someone to be upset after being brutally assaulted by a police officer and trying to be framed for something that they're exercising their legal rights to do, and when they have clear and convincing evidence proving that they were brutally assaulted by an officer in the city of Miami?
Respectfully to you, sir, it is not wrong at all.
Thank you.
But I am not the right person to have that conversation with about your being upset. There are many other people who are better suited to having that conversation. The conversations that we have here are for the purpose of resolving the lawsuit of Fawad versus the city of Miami.
Yes, Your Honor. So what do you recommend I do now, Your Honor?
I've explained to you now the arc of the case. You can discuss it with Mr. Harrison. You'll have to subject yourself to those examinations.
Subject myself as in being hospitalized or something?
No, I don't think so. They're outpatient examinations.
That's fine. I agree to that.
Okay. Thank you. Good luck.
Thank you, Your Honor.
Thank you, Mr.
Thank you, Mr. Harrison. Mr. Harrison, so my meeting at your office is scheduled.
No, we'll call you. You have 2 phone numbers, we'll call you. You do not have to come to our office.
Okay, Mr. Harrison. He calls me, Your Honor. My roommate calls me as soon as he says that. That's the type of harassment I'm talking about. And the individual who called me is harassing me at my house.